Okay, we are back and got the printer running again. Although we're not going to do a lot with the printer today, we're mainly going to talk through some of the intellectual property rights and um, legal issues surrounding 3D printing. For instance, we will start a print here in a second, but for instance, we printed this cube. So last time, or half of it, we only printed half of it, like the top half. We'll start another one of these because I haven't actually checked any of our temperature tower or tolerance test or anything. I printed one thing since we changed any of the firmware on our printer. And so we'll go in and we will print a couple of these again, but since we've changed the firmware, a lot of other settings could have changed, and there's one feature I want to show you on the new firmware that wasn't on what we had previously, or it wasn't enabled in what we had previously straight from the factory. But anyway, this cube down here, it has a license, and so it's one of the Creative Commons license. So if you click on this, you get a some specific guidelines on you are free to share, adapt. You can give a contribution to Creative Commons, the organization. The idea here is that there are some guidelines on what you can do with this particular model. Now, are these legally binding? Well, not currently, but they at least give some precedence on what the original creator of this object wants you to do with them. So I can copy and redistribute however I want to. I can adapt it, so I could maybe change it somehow, put my logo on it instead of that one or whatever. As long as I attribute where I got it from, so there's kind of a history of, hey, I started with this file and then I did this stuff to it, and that's it. So this one's pretty open on what you can do with it. Basically, the creator just wants you to say where you got it and who was the original creator of this particular file. Not all licenses are like that, and again, these Creative Commons licenses are a relatively recent way to try and mitigate some of the things that happen on file sharing sites and things like that. We'll get back to that, but for now, I've downloaded this and I've got it in Cura ready to slice, so that we can try and get a new print. Plus I want to show you this one new thing, and then we'll talk about the legal issues that in general, just not necessarily related to just 3D printing, but how they might affect 3D printing and what might be coming in the future as far as any kind of legal actions concerning 3D printing. So here's a little file. I've got it set to a 0.2 millimeter layer height. And everything's, I think, this the default. We haven't really changed any of these things. So you've got two walls, so that's two outer perimeters. The wall thickness, notice a lot of times these are, if I change this to 3 walls, it grays out this wall thickness because remember, the wall thickness, it probably needs to be a function of how big the nozzle is, which is 0.4 millimeters, and so a 0.8 millimeter wall thickness with a 3 walls doesn't really make sense. The slicer can't make sense of it. So I'm going to go back to 2, and now I could change this one and change the wall count. They're linked together. So I'm going to leave everything the same. We're not trying to do anything super fancy. We just want to make sure that our basic calibrations are in place, that this thing prints and it's more or less the right shape. Now I've already printed one part, not this calibration cube, but I printed another thing, and it looked really good. So we'll slice it, and 32 minutes, that's not terribly long. Let's put it on our thumb drive. We will eject our thumb drive and take it over to the printer. Let's get you where you can see the printer. There it is. Okay, there's a little SD card. Now sometimes I've noticed that it doesn't recognize the SD card inserted or not, but let's see if it did. It did. It says print from SD. Now I want to clean the bed since it's been sitting here, plus I just generally clean the bed. It's simple to do. and it is one thing that will give you a better chance of having the part stick down. Now this part's really small, so it's not going to have too much issue wanting to peel up, but still, no sense in not cleaning the bed. Alright, so again, this is just a little alcohol prep swab. You could use just a spray of IPA, isopropyl alcohol. There are some materials you shouldn't use to clean the bed depending on the surface of your bed. IPA is generally okay on most all surfaces, but you might think acetone is a stronger cleaner and you could get some of the older material off of there, but some material, particularly PEI, doesn't respond well to having acetone dumped on it. So, and generally you just don't want to spread out acetone unless you have to. Let's see if we can print our file. Print from SD. Alright, so it didn't show the file here, but it does have refresh, and clicking refresh shows my file. I don't actually know what it was called. There it is, I think. Okay, so it's going to start heating up, and then in a second it'll print. Once it gets started, we'll come back to it because there's a thing I want to show you, a feature I want to show you that's pretty handy. All right, I don't think we need Cura anymore. I don't think we need that. I think we are ready to look at our intellectual property. We can get started on this, wait for the printer to heat up, and then we can come back to the talk here. So the idea that I wanted to go through is just start out with what is intellectual property and how is it protected. Most of what I'll talk about really only pertains to the United States. Each country kind of has their own system for this. There are some agreements between countries on copyright in particular. The World Trade Organization has some agreements, but in general, you protect the intellectual property that you've created on a country-by-country basis. Maybe copyright is a little bit different than that, but most of the other things are just country-by-country. So what is intellectual property? So you'll see intellectual property written out, spelled out, talked about. Sometimes you'll see IP, so IP is abbreviation for intellectual property. And so it's some kind of work. It might be a creative work, it might be a song you wrote, it might be a 3D model you created, or whatever. So it's this work or invention, and whoever has conceived this thing and put it into practice, they're the person who has the rights over it. So that's the intellectual property rights owner, would be whoever thought up this thing. It might be a tangible thing, so you might have invented a product. It might be a creative thing, so you might have written a book, and all sorts of things in between. In general, those two things are protected in kind of mutually exclusive ways. So if it's a book you wrote, you couldn't patent it. And if it's I don't know, some kind of device, a 3D printer that you designed, you couldn't copyright it. So they generally are not able to be done the same. Although there are examples of ways that you could protect the same object from multiple angles. We'll talk about that in a second once we talk about the 4 major ways to protect intellectual property. So the 4 in the United States, the 4 major ways, and there are other more specific terms, but these are the general terms. So a patent is some kind of invention. It's a useful thing. It's novel, meaning that it's a new idea. It hasn't already been patented, or it's not obvious. It does have some, you had to think up this new thing. It wasn't just an obvious thing. It wasn't something that naturally occurred or whatever. There are trademarks. This is more on you're protecting your brand. So I've put the circle R in here. We'll talk about that. You might be more familiar with the little TM logo that says trademark. We'll talk about the difference in those two. But this is more on you're trying to protect your brand and your company. All right, we're getting close on our printer, so we'll go back to it in just a second. Copyright. So I put the C with a circle around it. And that would be a registered copyright. And then there's just the idea that you're just not going to tell anybody. You're going to keep it secret. And so this, oh, here, let's go back to our printer. I hear it going, and we need to look at something. So the new feature is called baby stepping. And what it does is, while things are printing, if you double click the knob, you'll see on the little screen here, baby stepping Z comes up. What this lets you do is you can turn the knob as your print is actually occurring. So we're printing over here, and you can raise and lower. So for instance, I'm maxed out. I can only raise, whoops, all right. So I can only raise the nozzle right now. I can't go any lower. Actually, oh, there we go. There we go. So see, it didn't stick. And this is why I might have wasted too much of my time talking, but I think I saved it. So this is why you do the little brim, or one reason you do the brim. One reason is to purge the nozzle, but another is that it gives you time to make little fine adjustments. And so what I did is I turned, and notice it's saying negative 0.675. I actually was able to make the nozzle closer to the bed as it was printing, versus having to like turn all the knobs on the printer and that sort of thing. And so now I think we actually got it close enough that it's going to stick to our bed and the print will survive. Had I just let it go, then I just slid this off. It wasn't hardly sticking at all. You can see it's not the right shape. It should be a square, and that's because it was just kind of floating above the bed trying to print with not really sticking to it. And now I think it's going to be okay. So baby stepping is a really useful feature to have enabled, but by default from the factory it's not enabled on the Ender 3. This particular firmware that we uploaded to it last week has it already enabled. Other firmware it's built into but not enabled, and so you might have to go into the firmware code itself and enable that particular piece of code. So we'll get back to this printer in 30-ish minutes or so, and hopefully it's done. Let's go back to our idea of intellectual property. I may have to move the printer if it's too noisy. It's kind of not very loud, but one of the things we'll do later on in the quarter is try to make it a little bit quieter by changing out the control board and maybe some of the fans. But it's not horribly loud. So here are our four types. We have patents, we have trademarks, copyrights, and just secret. So you just keep it as secret knowledge that only you really know, and you don't share that. So let's go through these. Let's start with patents, because most people think of, if you have intellectual property, you patent it. So that's generally the first thing you think of. And of the four, it's arguably the toughest one to actually obtain, depending on what you're trying to keep secret. Sometimes keeping something secret is actually pretty easy, but other times it's not so easy. So actually keeping something a industry's trade secret is tougher than getting a patent, but we'll see, because there is a downside to patents. So I went and this is one of the drawings from the first patent for FDM printing. At the time, I don't know if it was called FDM. FDM is the fused deposition modeling or method, and it's actually a trademarked term for this style printing. It's the top style printing we're doing over here on our Ender. So this is one of the drawings that was in the patent application back in 1989 is when this occurred. Actually, before 89, there were 3D printers, but they weren't this style. They were SLA, so they used a laser curing a vat of resin, which is still in use today. So this would be part of the patent. You'll see all these numbers. They're referencing the description in the patent. So what a patent does is basically it's an agreement between whoever has created this object, this 3D printer or whatever it is, and the public of the country that this patent exists in. And the agreement says that for full disclosure, so in other words, the inventors have to fully describe the invention. So they have to tell everyone exactly how this product is made and how it works and that sort of thing. what they get in exchange is exclusive rights for a period of time. In the United States, it's 20 years. So for 20 years, those inventors have exclusive rights to to basically control how the technology is distributed, how it's imported to the country, how it's used, not how it's used, but how it's sold and how profits are made from it, basically. And that 20 years is from the time they filed the patent. So this particular patent, here I have the link to it. Let's see if we can follow it. Maybe slowly coming up here. Well, maybe it's not gonna. There it goes. All right, it's just slow. So here's the patent. Well, in Google anyway. This is Google's version of how to present it. But you can see over here, they actually applied for this under a company named Stratasys, which still exists, on October 30th, 1989. And then it was granted, application granted, June 9th, 1992. So 3 years later, or 2.5 years later, before it was actually granted. So there was a period of this 20-year time frame that they didn't actually have a patent. So that's why you'll see a lot of objects that have patent pending written on it. That means that they have done the filing part, but they want to go ahead and get that product out to market and start making money off of it. So they say that, hey, we've applied for a patent. We haven't actually gotten the patent number approved or anything yet, but we anticipate it's going to happen, and we have done the process of beginning to file for this patent, because you only have 20 years from when you filed it. And in fact, if you notice that time frame, 89, and then add 20 years to that, that is the same time when the 3D printer of this type with the FDM style printer started becoming available at the hobby consumer level. These Stratasys printers commercially were much more expensive than what you could get at the hobby level. They were nicer, they were enclosed, and they had a heated build chamber. They could print ABS, or their version of ABS, really well. But as soon as that patent expired, all of this full disclosure was now available for anyone to use. So you could make your own version. You could sell your own version if you thought you could compete with Stratasys. And that's why you see about that same time frame, 20 years from 1989, these patents begin to expire, and there are people putting out kits, starting to make printers of this style available at the consumer level. Patents are filed with U.S. Patent and Trade Office .gov, uspto.gov. You can go there and file one. Generally, filing a patent is an expensive process. Well, let me say that wrong. So let me say that a different way. Filing a patent isn't terribly expensive, like the fees that you pay, but actually getting a patent awarded, writing one in a way that it's useful, going through all of the language to make it a useful patent that isn't just going to get superseded by some other product shortly, or it doesn't have strong claims, that's expensive. You're generally looking at, for a good patent, in paying the right people to produce the patent language and do the background research, it's starting at $10,000 to get in that range. Now, different types of patents. The one that you generally think of is called a utility patent. That's what would be what this would be. This would be a utility patent. So it means that you're basically protecting a product, some kind of technology, a machine, something like that. Now this is where I said generally copyright, a thing you wrote or whatever, and so a creative thing versus a product don't overlap. There are these design patents. They're cheaper to get, they are simpler to get, and basically they are kind of a bridge between the creative aesthetic side of things and the functional side of things. They don't last as long. I think they last 15 years. And what they're trying to do is protect the appearance of an object. So the shape of the bottle or whatever might be a design patent. So it's more on the brand side of things versus the function side of things. And then some of these others over here, there are plant patents. So agricultural plants can be genetically modified to do certain things, and then that secret recipe for that particular plant can be patented. There are some for computer software, although some countries specifically exclude computer programs from being patentable, and generally they fall under copyright. But there are some cases where you can patent a piece of computer software in the United States. And then business practices, I put new, they're the new-ish type, I think. Actually, there might be something new. I'm not like super up to date on what's out there in the patent world, but they are kind of controversial. One of the prime examples of this that gets used a lot is Amazon and their online shopping cart, where you could, or digital shopping cart, where you go down, pick items, and they kind of pop into your shopping cart. And they actually filed for this and were awarded it. And then it turned out that there was another much smaller company that was already doing this, and they had proof that they had been doing it well before Amazon was. And I think that patent was revoked. So it is possible for a patent to be disputed and revoked later on. So generally, though, we're thinking of utility patents. And they're pages of, do I still have that other one open? Yeah. So there are pages of, descriptions and claims. The most important part, I don't know if it's going to show, oh, here they are. So over here on this side, the claims, that's the most important part of the patent, because this is what the patent is claiming the technology does. And so this particular one has 44 claims. Let's pick one. Apparatus as defined in Claim 7, wherein said flexible strand is a thermoplastic resin. So basically, it's using the thermoplastic resin. That's the filament. So they're kind of just trying to define loosely. So it doesn't say anything about the size of it, the color of it, or anything. It's just kind of, they said flexible. So that is even general. Now this Google, actually, when I click flexible, it does go over here and give me some description of what that means, or some references to it. Strand, so it doesn't even say it's round. It could be, maybe it turns out that it needs to be a hex shape cross section or whatever. So it's generically written, but not so so it's not so specific that you could easily say, well, no, you said it was a cross section that was circular, but our device uses a hexagonal shape, and that's totally different. So you have to write these things in a way that is generic, but still specific enough that it means something. So that's the key to writing a strong patent, is all of these claims. And this one has 44 different claims. All right. And so that's why usually utility patents are expensive to correctly get, and they are time-consuming to receive. But yet you're on a time frame. So once you start putting your product information out there, you have publicly disclosed it. That will also start the time frame in which you are able to patent something. You couldn't go around selling a product for years and then decide to patent it. It's already out in the public domain. So without being patent protected. There is a opportunity that I didn't write here called a provisional patent. So basically what that is it's a 1-year patent that you can go ahead and file for, so that you can start talking about your object, your product, getting some traction on the business side of things without the full-blown patent being in place. Basically saying that I think this is a good idea. I'm going to file for a provisional patent. They're generally much simpler to do. You can do that yourself even. Although I wouldn't recommend just totally doing it yourself if it was something you were hinging your whole business on. But they are much simpler to obtain, and they give you a year to go ahead and publicly disclose your product, get investors interested in it or whatever, with some amount of protection. copyrights. So a lot of 3D printing actually falls into this copyright category because all of the files, like the file that we downloaded from Thingiverse, if you think about it, that file, if I were to open it up, it would look no different than a Word document of a piece of text somewhere. You know, obviously it's a bunch of numbers and letters. It's not a thing you normally can read, although it can be read by somebody that knows how to read G-code. May not be very entertaining, but you could read it. And so most of the CAD files, so you have a CAD file for a CNC machine, which is the same thing as a printer, 3D printer, those files themselves fall under copyright. So without express consent, you can't just go and steal, copy a STL file. You have to have a permission to, and so that's what Thingiverse is trying to do. Is they are offering up a way that people who are going to give out permission to use their file can do that. So what copyrights do is they protect written things, play, music, some kind of artistic work. So it doesn't have to be written. It could be a sculpture or whatever. But it's something that's not necessarily considered on its own to be a useful product. So it's more a creative product. The default in the United States and most of the world is that as soon as you write the thing, it is copyrighted. It is not registered as a copyright, so you can't put the Circle C on it saying that it's registered, but you can write copyright in whatever year you wrote it in. You don't even have to do that. Technically, it is copyright protected as soon as you write it down. In the U.S., copyrights are filed in the Library of Congress, and they have this weird term. And it changes also. This is the current one. The current term is however long the author lives plus 70 years. So basically, it's trying to show that the author could write something or create a thing, and then some of their family members could still benefit from that 70 years into the future after the author has died. If it's a works for hire, so if you work for a company and they hire you to do this creative work, write a movie or whatever, then it lasts for up to 120 years from whenever it was published. Now this, I don't think I wrote it down, but the original terms on these were much shorter. But I didn't link it here, but in the video description, I linked a document called How Mickey Mouse Keeps Changing Copyright Laws. And it's interesting to read because it's not totally all Mickey Mouse, but you can kind of track wherever Mickey Mouse, the Disney Mickey Mouse character, whenever his copyright was about to expire, some lobbying would happen and copyright laws would be extended. And if you notice, Mickey Mouse has kind of changed again. If you remember what he used to look like several years versus what the current Mickey Mouse cartoons look like, they look a little different because his copyright's going to expire soon again. And currently, no one has changed these limits here. The 120, that would be a works for hire, so they haven't changed the 120-year limit yet. But it could still change. That's an interesting article. I'm pretty sure I linked it in the video description. And it's not terribly long either. This Berne Convention, this is one of the agreements where multiple countries get together. This is one the United States is part of. Originally, they weren't part of it because in the United States in, I think the 80s or sometime, the deal was that copyrights were not automatically granted in the United States. You did have to register for them. But to be a member of this convention, that was not how it was working. They had to be automatically generated as soon as the work was created. And so the United States I think it was in the 80s or so, they did change their laws to say that copyright is automatically granted. And now they're a member of this convention. What it does is that it helps to carry copyright protection across international borders, so that you don't have to go and try and get a copyright in every country, or you don't have to go sit down and write the thing in every country, or however it would work. Like I said, computer programs are typically protected as literary works, not patents. Although, again, you're trying to get the distinction between patents are normally trying to protect a functional product, and copyrights aren't really products, they're creative works. And so you can always find someone willing to argue one side or the other, and that's why there's courts that do a lot of this kind of figuring out, is this a copyrighted thing or a patented thing, or is it neither, or is it both, or how does it work? Like I said, CAD files are typically protected by copyright. Why you might register, and registering for a copyright is, I think it's like $50. It's not expensive. It probably depends on what exactly you're registering, but it's not an expensive thing. It is optional, but if you do register with the Library of Congress, then if somebody copies your protected work and it's registered, then you automatically have a amount that you can sue for damages. If you don't have a registered copyright and you want to sue for damages, you have to go in and prove how many dollars of damage that infringement created. So it's much more difficult to try and figure out. So if you ever plan to actually protect your work, copyrighted work, then you need to register it so that you have, I think it's like $150,000 for infringing on a registered copyright. Otherwise, you have to prove how much damage was done. Trade secrets. This is the one that is not actually a legal thing. It's only legal in the sense that you're talking about theft now. Somebody actually had to break in and steal your secret formula. So it's legally protected on that side, but it's not like a patent or whatever. So the difference, remember, a patent, you had to fully disclose how it was done, and then you only had that exclusive protection for 20 years. Maybe you envision the thing that you thought up is not something that's going to be easily duplicated just by looking at it, and you want it more than 20 years. You want to, sell this thing for hundreds of years. So the classic example here is the formula for Coca-Cola. It's not a copyright or patented thing. It is a trade secret where, and I don't know the details, but the things you hear are that no single person knows the entire formula, and it's all distributed out amongst different people in different locations and whatever. They're not protected by federal law other than the fact that you would have to take the formula in order to obtain it. You couldn't just think it up. It is possible that someone with the right equipment or the right sense could replicate it, and there's nothing that can be done about that. And there's a lot of not Coke products, other colas that are not Coca-Cola, and they're just copying something that looks like Coke or kind of tastes like Coke. They can't use that logo, though, because that logo is trademarked. They couldn't use that bottle shape. That bottle shape is probably trademarked and maybe even a design patent every 15 years. One thing about patents I didn't mention is that once the thing is patented, it cannot be patented again. So you couldn't just refile. Whoops, didn't want to do that. You couldn't just refile the patent. You have to create an alternative thing and file a new patent. So that's why things do change over time, not just only to keep up with current demands, but because you can't re-protect one that's already been protected. Trademark is the other type of protection. And again, this is more on the business side of thing. On a brand, you want to distinguish from similar products so that you're buying the Coke bottle and not the Pepsi bottle or whatever it is. You do have to actively use these. You can't just trademark something and then never use it. So you have to be ready to protect your trademark. And it's not just logos. You can trademark a sound or a color, a smell, a slogan. It doesn't have to just be your company's logo. If you go into a mall, you probably notice that certain stores smell certain ways. that's not on accident. All of that is designed and even trademarked so that you reference that smell with that product and that store, so that the next time you go in a different store, it's like, that doesn't, mentally, subconsciously, you're thinking that doesn't smell the same. And the idea is that you're more pleased with the other store. This is also with the USPTO, so it's U.S. Patent and Trademark Office. Copyrights were Library of Congress. Again, relatively inexpensive, probably in the hundreds of dollars versus the thousands. There's two different logos for this. Trademarks is another. Trademarks are another thing that are automatically generated. You can use the circle TM, or the little TM. I don't know if it's always in a circle, but the TM, and you can just write that. You can draw up a logo or whatever and put TM on it, and that is you have trademarked it. But again, to actually register it, you go to the USPTO, file for it, describe it, and the cost depends on what it is you're actually trying to trademark. And then that's the circle R, is a registered trademark. Okay, our print is really close to done. Let's see. It says it's 80%, so got a few more minutes on that. So let's keep going here. Here are some terms. Assignment means that this is particularly true for patents. So a patent has to be assigned to someone who's going to own the patent. And so sometimes if you work at a company, you might have invented the thing, but you have to assign the patent to the company you work for. And most companies are that way. Licensing is, once the patent exists, then you could exclusively license this patent to someone. So it's kind of like, I put this similar to leasing in real estate. So you own the house, but you're going to let other people use it. You could let just one person use it, and that's an exclusive. Only that person can live there. Or maybe it's got a lot of rooms in it, and you're going to let a lot of different people live there. So that's non-exclusive. So it's the same idea for a patent. You own a patent, and you're going to lease it out to one person, and only that person. So that's exclusive, and that person or group can do what they want to with it for however long the term of the lease or the license is. Or it's non-exclusive, and you're gonna license this thing to 5 different companies and let them all produce the product that you've patented. Does it mean that you are going to make money if you have thought up some kind of intellectual property and you even got a patent? Well, here's kind of typical numbers. So this would add to 100. So this would be out of 100%. 5% of the time, it's not even an invention. Someone else has already thought it up. It's already patented. It's patented in 1890 or whatever, and so it's not an invention. It's already done. So there's 5% of the time it's just not even something that's an invention, or it's an intuitively obvious thing and you can't patent things that are obvious. 30% of the time, there is some obvious problem. So it's a great idea, but you can't make the perpetual motion machine. It defies laws of nature. So there's some obvious problem with the idea. 45% of the time, you've got some IP, particularly in this case, thinking of like you have gotten a patent. Now, you probably couldn't actually get a patent if it's not an invention, particularly if it's already been patented. You can't get a patent on that. But a lot of these patents, the patent office is not necessarily going to tell you that it will work or not. They're just following, is it patentable? Has it already been patented? Is it novel? Is it useful? And so they keep a generally broad idea of what useful means. So some things could fall through, but not things that are not patentable because they are not novel, or they're already been patented, something like that. So almost half the time, the thing gets dropped after some first round of funding. So you get a little bit of investment. Maybe you went to the bank and borrowed some money, but you just couldn't make it work. 15% of the time, you'll get that second round and maybe even license it out. So basically at that point, you're recouping all the costs you put into the development. So you're breaking even. Another 5% of the time is when you actually start making money on these patents. So having a patent is not a guarantee that you are going to be a wealthy person. For one thing, the patent is only good if you're willing to protect it, which usually means lawyers and courts and things like that. Here's an old patent from 1897. I don't know if this one made money, but it certainly looks like one that probably didn't make a lot of money, but somebody got it patented. It's issued. I can't see the patent number. There it is, 586145. So they're sequential numbers, so you can tell how many things have been patented just by the number of the most recent patent. But this one's in 1897, July 13th. And it's some kind of duck blind for some hunters inside a cow costume. I never did go back and look and see if this was ever produced. It may have never even been made. Actually, in the older times, before I think maybe the 70s or so, you actually did have to have a working prototype to bring to the patent office. You no longer have to show a working one. You have drawings of everything. Obviously, a working one is more likely to get patented, but oh, I hear a printer. All right, let's go over it real quick and see how our print turned out. It did complete. It generally looks okay. You know, it's got some, I don't know if you can see very well the colors, but you can kind of see how it's got a little bit of some uneven layers there. Maybe that's something we can work on. It's got a rounded corner over here. That's something that we will try to work on. These different colors, a lot of times, yeah, you can see the bands in there of different colors. A lot of times when a filament comes out with different colors, that's kind of an indication that it's printing at different temperatures. So maybe there's something that we can do to regulate how our cooling and temperature control on our printer is doing. But overall, it's a good print. It's not bad. Oh, so this one is supposed to be 20 millimeters by 20 by 20. I don't think I have my calipers. Well, got a ruler. This will get us close. Not on that side though. Let's see if we're... So let's see. It's pretty close to 20 there. Pretty close to 20 there. Pretty close there. Well, that was just the top. Alright, so we're a little short though. So look at that. It looks like we're only about 19 millimeters tall. We'll have to actually measure that. So one of the reasons it could be short is that our z-axis is not calibrated correctly. Let's move our z-axis, moving up and down. But I can feel, I don't know if you can see, I can feel that the bottom layers are squished out. They have that elephant foot. Remember I did the baby stepping and I stepped it down 0.675 millimeters. So I've lowered the nozzle 0.675 millimeters. So we probably have some work to do on getting the nozzle just the right height above the bed. Is probably why it's, most of the reason why it's short. And I can feel that these bottom layers are kind of sticking out a little bit. It's not horrible, but I think we could do better on that. All right, so let's turn that thing off. Oh, and it took 35 minutes. Our estimate on Cura was 32 minutes, so that was reasonably accurate also. All right, back over here, and then we'll talk about this a little bit more and call it a day. So how does 3D printing fit into this? It fits in a lot of different ways. So copying an object through 3D printing, first of all, it doesn't specifically raise any IP concerns. So it just because I copied this guy, wherever he's at, copied this, doesn't necessarily mean I have violated any copyright laws or patent laws or anything like that. In fact, this one, we looked at the license and it certainly said, now that license is not necessarily a legally binding license, but if in the future something like Creative Commons is ever legally adopted, then there's a history of, hey, well, it said it was okay at the time, but it's more the intent of the creator is what you're getting across in the Creative Commons. And there might be, I don't know if anyone's ever tried to sue based on a Creative Commons license or not. Maybe they have. I don't know. I'll have to investigate that. But we didn't actually break any law by printing that thing. But you can certainly think of scenarios where you would be in violation of some kind of law. So like I said, copyright generally protects the file itself. So the STL file or the G-code file. Now you could argue if the STL file is what's copyrighted, that's the geometry. So that's all the little triangles that make up the geometry. The machine doesn't use the STL, it uses the G-code file. And so where does that line end for, well, I downloaded a STL file, but I myself sliced it using Cura, or maybe I wrote my own slicer. So am I violating the law then, a copyright law, because I didn't copy the STL, but I used the STL to create this other thing? So there's all these little minute questions that have to be sorted out. A design patent. If the owner of this had gone in and protected this particular design with a design patent, then yeah, I couldn't copy that, could I? I couldn't produce another one that looked just like it. Now, would he care? Probably not, if I'm sitting here in my little space making these little cubes. But if I started selling those, particularly, if they've got his logo on there and I'm selling them, then there might be an issue, but only if he had applied for this design patent. Utility patents protect the function. So maybe I'm printing something that's a functional object. I might have complete access to the code that created it. Maybe I created it myself. What if I wanted to replace a part on my car, and I made a copy on my own. I know how to do some SolidWorks modeling, and so I've modeled up this whole part, but it's an exact copy, my version, of a part on the car. Then I have, and it was a patented part on the car. That's the key, is that we're talking about it's a patented part. Then what happens then? If I use the part on my own car, have I created any problems? Probably not. If I sell the part on eBay and I start selling thousands of these things, maybe so. I knew a person who, now this was more on the trademark side of things, but it was a part for a car. The logo on the front, the emblem of a car, he was water jet cutting, I think, versions of these to make into necklaces. So he would cut out a Toyota logo and polish it up and maybe chrome plate it or whatever and sell that. Or he was, I think the other thing that he was doing was he was making replacement logos to go on the car. And in his case, actually Toyota, or whoever the company was, I don't remember if it was Toyota, but they found out about this and they made an agreement like, this is getting our brand out there further. So as long as you do this, then we'll let you do that. So if you can come to an agreement between the actual owner of the protection, whether it's a patent or a copyright or whatever, trademark, then they will essentially license you some limited ability to work in that space. But 3D printing kind of is different because you can go in and I could create a file that looks just like another thing. I could scan it. There's some laser scanners that are very accurate. I could scan a part or a statue or whatever, create my own CAD file from it. So I'm not stealing the industry CAD file. I've created my own. And then, so I haven't violated copyright necessarily. somebody might argue that I did because the intent was the same, but I didn't literally take their STL file or their CAD drawings and make my own version. I took the part and reverse engineered it. So I haven't violated any copyright, but when I make a new one of it, if I am making the new one as a replacement for the product and the function of the product, and it's essentially the same product, that's where maybe if that thing's patented, it has a utility patent on it, I probably am starting to get into some violation, even though I'm using a different manufacturing method. Probably most of the manufacturing methods are not 3D printing right now. So there is this vague ground that hasn't really been worked out yet about how things like 3D printing affect the intellectual property. But the same kind of thing happened when print shop became available in the 80s or 90s or whenever it was for PCs. Before that, it's kind of hard to make your own banners and whatever on a computer anyway. But now you could buy a little piece of software and your whatever computer you were running in the 80s could print out all day long a little dot matrix printer these banners. Or you can, when the Xerox machine came out, you could, in the 50s, I guess that was, or 60s, you could copy things. In fact, the Xerox patent, I should have brought that one up. It's actually an interesting one. It was one of the ones where the technology didn't match up with the industry at the time. So this will be, do we have time? Yeah, we have enough time for this aside. So Xerox comes out, and I think it's in the late 50s. I'd have to look it up. But they come up with the Xerox machine, the photocopier. And at that time, the way you made copies was a mimeograph machine or just carbon paper or hand copies or whatever. And so their technology was way superior. You just put the thing on there, it scans it, and makes a copy of it. But nobody bought it. For years, they got the patent, they made the products, and nobody would buy it on any scale to make the company profitable. What they ended up having to do was give the machine away to a company and say, we'll give you this machine, put it in your office, you make 1,000 copies a month, and then anything you make over 1,000, we're going to charge you some amount, like 5 cents or whatever, per page that you make above 1,000. And every company's like, well, sure, we'll not make more than 1,000 copies a month. That's ridiculous. Because they're thinking of their current technology, and it's not easy to make that many copies. And of course, it turns out that they make way more than 1,000 copies a month because it's so much better, and they finally get some market share of their own in the copy business, and Xerox is a big time company. Let's see. So that was just an aside about how market and technology don't always line up, but it can work out. Here's some other thoughts. So this print, this little guy, he started out as a digital file. We downloaded it. So that does probably mean that file was protected under copyright law, since it's similar to software. The part that's on this little SD card, though, the file on this SD card, I made on my computer just now. You saw me make it. I hit slice, and it sliced it and made that file. So is that my file? I don't know. Probably not. That's similar to a CNC CAD file, although I didn't take it directly. The technology exists where I can create my own version of it. That probably is still under copyright law. So it's similar to copying video and music files. In fact, I put the DMCA over here because this is more or less how things operate right now. This is Digital Millennium Copyright Act, I think. So what happens here is you might have heard of a DMCA takedown or whatever. If a file on Thingiverse or someplace like Thingiverse, so I'm thinking specifically of 3D printable files, so STL files. If a company thinks that that is their file, like whatever you put up there looks a whole lot like one of their things. So it's a company that makes some kind of little figures, and that looks a whole lot like the figure that they make. And they claim a copyright on that. Then what they do is that company goes into the website, Thingiverse, or whatever your file sharing site is, and says to that site that I believe that this file is in violation. The website will take the file down and inform the poster, whoever originally uploaded it, that, hey, your file was taken down because so-and-so company thinks it's in violation of their copyright. And then the user that uploaded it says, well, no, I made that myself, and I don't think it is violating their copyright. And so they respond to the website. It gets put back up, and then it's gone a message back to the company that said to take it down and said, no, this user says they made it themselves, blah, 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 and they don't think they're violating your copyright. And at that point, that company has to decide, are they going to actually take legal action or not? Were they just kind of being overly protective and it's not really something of theirs, but it looked like it? Or do they really think that they are losing money because that file is on the web somewhere? Once it's on one website, it's on everything somewhere. So at that point, legal action may or may not be taken. So the same thing on YouTube. If I were to put a song in this YouTube video that I didn't write, somebody else wrote it, I just played it, then it's very likely I would get a DMCA notice that song violates some copyright, and then I'd have to either take that song out of the video, or I would have to say that, no, I wrote that song, and prove somehow that I wrote it, and then there'd be this back and forth and maybe legal action. This is induced infringement. So we talked about the idea that you upload a protected file as Shapeways. This is a company that you can upload STL files to, and they will print them to anybody. So I could upload this. Well, I wouldn't upload this one because I didn't make it. Maybe I make my own version of this calibration cube. I upload it to Shapeways and say, hey, anybody can print this if they want to. It costs $3, and Shapeways will charge them the money and some more money so that they make a profit, and upload that and print it out for them and ship it off to them. What if the file that I uploaded was one that was protected? So I have induced someone to infringe on a copyright. They didn't go out of their way to infringe on the copyright. I am the one who induced it because I put up the copyrighted file. Who's at fault then? The people that ordered it, the people that printed it, or me because I uploaded one? What if a contributory infringement? What if I specifically create a file to copy another thing? What if this was protected, and I specifically go in and measure everything and make another one of these exactly the same, and I upload that one? So now I'm contributing to infringement. I'm not just inducing it. I'm like specifically trying to do it. What if Alice? So Alice and Bob, those are typical generic names in computer science. So A and B basically. What if Alice purposely and illegally obtains a CAD file and uploads it to Thingiverse? Maybe she works at a company that has a bunch of CAD files, and she takes one and uploads it to Thingiverse. And then Bob comes along, he downloads and prints that file because, hey, I need one of those things. Who's at fault there? Is Thingiverse for not recognizing that this is a copyrighted file? Alice, probably, certainly. What about Bob? He knows he's using it to replace another thing, but he doesn't know where the file came from. So there's all these type of issues that have to be answered. Right now, the DMCA is one way that this is happening because most of these files get shared through a site like Thingiverse, and a company can go through. Now it has to be active, like the company has to be searching periodically for infringements, and a lot of times it's not worth it to hire somebody just to look through Thingiverse for things that might look like your product. But it sometimes is worth it, and some companies do that. So currently that's kind of how it's handled, is this DMCA, and that's more or less how it's going to be handled for a while, until something big enough gets out there, something bubbles to the top, and a company does start to see a reduction in revenue, and they can trace it back to some sort of 3D printing or copying through 3D printing, and then they'll start to take legal action at that point. If I sit here and print out, these little things for my own use, and it never gets outside of my domain right here, then nobody's ever really gonna bother to come in and to copy that. Now, if I start producing those, or if this thing is really valuable, if this thing is $1,000 to buy one from the company, and I make one that you could print on your own for free, or for whatever the cost of the filament is, and it's just as good, then the company probably would come and try to exert their copyright or patent protection, whichever it is. I would question, what are they doing if I can make a thing like this for, essentially no portion of the cost that they make it for. Maybe they have a bad business model, or maybe a really good one. I don't know. But there could be some legal things. So right now, in general, if you aren't selling the things that you're printing, then you're probably okay. Most of the things, even on Thingiverse, don't want you to sell them, although I don't know that there's actual legal action that can be taken other than a request to take it down, don't sell this kind of thing. They do have the Creative Commons, but I don't know how legally enforceable that is. It's more of a community standard than a legal standard. So I don't know how much you have to worry about those type of things, but at some point you can imagine a scenario like here with Alice and Bob, where it is directly going to violate a law at some point, because there's some theft of intellectual property involved and some intentional use to circumvent a product. That could be an issue. It is still being sorted out, and it's going to continue to be sorted out. But I think as long as you're not, selling things on mass scales, that you're probably fine. If you're just printing out your own version or whatever, then that's probably not much different than making your own version any other way, regardless if it's a printer or not. What 3D printing comes in that's different from hand carving or whatever, or taking a drill and making your own part, is that with 3D printing you don't have to have a lot of skill, right? It takes some skill to get your printer running, some knowledge anyway, but you don't have to have any craftsmanship necessarily to create the thing. You download the part and hit print. And if your printer is working well, which you could buy a better printer that works well out of the box, then that's the difference, is that it doesn't take that background knowledge, and so there's not this kind of barrier that you have to get over. Almost anyone can go in, buy the printer, and print out decent replicas of stuff. Depending, especially if they spend more money on the printer, they can print out much better replicas of things. And so that's where it creates this little bit of difference in what traditional copying, whatever could be. It kind of is like literally photocopying a book somewhere, that we're in that realm. And so there are clear laws against that, but there are fair use laws also that let you do copy portions of things. And so it's going to all work out somehow. And in the next several years, I think this will come out more and more in the legal system, sorting out what does it mean. They're going to have to figure out how do you sever the idea of the copyrightable part from the functional part of the print. So how do you sever the part that's copyrighted and the patentable part? Okay, I think that's enough talking about this. I just wanted you to have a general idea of, if nothing else, what intellectual property means, and the different ways you might protect it. There are no real answers to the 3D printing and copyright and all that kind of stuff. There's some vague guidelines currently, but I don't know that there's any landmark case that's been determined on copyright, patent, and 3D printing. Not that I'm aware of anyway. But anyway, it is an interesting topic. Next time on Wednesday, we're going to get back to our printer. And my plan is to get into the firmware some. So it's kind of going to be a software thing, but kind of hardware also. Our idea is that we can get in here and account for a bed that's kind of warped. like it's got a bow in the middle or a sink or maybe some waves in it, and without a probe. So with just what we have on here, no special attachments or anything, we can do that, accounting for an unlevel bed or unflat bed, so it doesn't have to be level. It's just not even flat, without adding any special equipment, just using the firmware that we installed last time on Friday. All right, I will see you on Wednesday.